Adrian is his constituent. Do you concur, Adrian? Can you look at that? Tell me if that's accurate.
It is accurate. I even sent it to you the day we first started talking about this.
She was the one that sent it to me. Okay, this is not about Grog. Okay, the primary evidence on the U.S. government's fucking website says that he was not there for the first or second roll call. It's not up for debate.
Okay, I'm going to double check into that. I'll look in the. It's from the House.gov.
It's in the Jumper John, and the link is added as a reply directly to it. Yep, U.S. House.gov.
Okay. I'll take.
It's like the same thing that Alex Jones is doing. Like, I want to debunk the proof.
No, I'm willing to take a look. I'm open-minded about this.
And I even scanned.
There's this tiny man in the corner, and it is him. I tell you, it is him. I tell you, you can't tell who it is, but it is him. Don't mind the record. The record means nothing. The blurry picture is everything.
Like the plane I even watched the video. I even watched the whole video.
I have respect for him, dude. I swear. Like, it's crazy. You could tell he's lying. Like, the motherfucker's lying. He's doing that Trump face right now. Like, you could tell when Trump's lying.
All right. I think you're ready. Go ahead.
Yeah.
Did I burn enough time?
Yeah. So, what I'd like to do is, before I talk about the attorney disqualification motion filed by defense, is just do a really quick, like 30 seconds on the other each on the, the other mini matters that have been going on. Number one, pretrial publicity, aka the gag order. So the judge ruled from the bench at the hearing, and that formal order has been published. It's with much better description to make it more reasonable. Again, the gag order applies to the attorneys, but the attorney, it doesn't necessarily apply to witnesses or non-attorneys. It is the obligation of the attorneys to inform witnesses or members of their team, not to talk about the case. They really can't technically enforce it, but that's their obligation, is to let them know that they are under a gag order. They certainly can't, encourage witnesses to go around and talk about it. Preservation of evidence. There had been, that is now closed. There had been about a 6-week back and forth of motions regarding the details of the preservation of evidence.
Did the cell phone ever come up?
The cell phone has not come up, and based on the timeline that we've put together in this case, never mind standard operating procedures and protocol, we're just talking about this case based on the timing of the first motion filed by the defense in regards to preservation of evidence. Now, I mean, there's already rules in the road in terms of how seized evidence should be handled. Based on that timeline that goes all the way through, and then the back and forth motions, a prematurely issued order that was then set aside, and ultimately both parties agreed on a process for evidence to either be released or to be tested in a manner which could result in destruction of the evidence. Forensic evidence, DNA testing, etc. There's a 14-day period where prosecution has to notify the defense. So there's been no notifications, at least not on the record. And even if there was, based on the timing that the two sides agreed on this order, which the judge signed, it doesn't look like the phone was ever seized. The only opportunity, they would have had to have seized the phone shortly after Charlie Kirk's murder, copied everything, and then gone against all the protocol. They would have had to have done that within about a 2.5 week time span in September. So it is highly unlikely that they ever took the cell phone. So we're just going to let that sit. But there is a preservation of evidence agreed upon order by both sides. These are the rules of the road. The best example and what is talked about in the filings by the state's position is like we shouldn't have to hold on to everything. For example, Tyler Robinson's parents want his car so they can sell it, so they don't have to make payments on it. So that was the example they've given. So if they still have his car, if they ever had the cell phone, I'm sure they would still have that too, and would not have released it. So that is preservation of evidence. Media coverage. This is the consortium of news outlets, small local radio newspapers, radio stations, TV stations, and then also national news media, AP, New York Times, Fox News, etc., that have filed to become parties to the case, so that they will get formal notices of any closure hearings or classification of evidence. Both the defense and state, object to their becoming a formal party. They don't necessarily object to them receiving notices, so there's some nuances there. I think generally both the state and defense would like to have this as closed a process as possible. There's been no ruling on that yet, at least as of yesterday. So that is still pending, the media interveners intervention. Technically what they're asking is for it to be, a limited party, so not full parties to the case. So that sits. And that brings us to attorney disqualification, which Sam had mentioned last week, and let me put a fine point on this. What happened is the defense last week filed a motion to disqualify one of the attorneys in the Utah County Attorney's Office on the prosecution team, because that attorney received text messages from a relative who was at UVU and received text messages within minutes after.
Do we know for a fact who the relative was? Is it?
I do. It's probably been recorded, and since I'm literally just dealing with the facts, and what has been redacted from the public version of this is just the name. So we don't know the name.
Because there's people saying that it was Farnsworth, but when I hear you talk about the dynamics of it, it doesn't sound like Farnsworth.
There was discussion about a conflict of interests involving Farnsworth and the defense attorney. That's a separate discussion.
So that is separate. So these are two different things with the attorneys. Okay.
There is no, and we can talk about Farnsworth, and I hope it will be very brief.
And he didn't.
So this is a member that received text messages from a relative who was there at the time. The defense filed a 14-page motion calling for the disqualification of that attorney because of the potential conflict of interest. That conflict of interest would be based on, in the course of the statement of that relative was a witness, and that witness's testimony conflicted with another witness. The witness who is a relative of the state's attorney lawyer would be naturally biased. I want to point out that the prosecution team did disclose this to the defense early on, back in early October. So this is not a situation where that wasn't disclosed, and even in the defense's motion, they say this is not an attack on the attorney's integrity. I actually have more experience professionally in the area of conflicts of interest, more on a corporate side. But the most important thing for me, the first thing is the transparency and disclosure of a potential of an actual conflict or a potential conflict of interest, or potentially perceived conflict of interest. So I think that the prosecution did the right thing, disclosed it to the defense, and and the defense believes that this is enough and they explain, they give I think a very good reason for that, and I think it seems like a strong case to disqualify that member of the prosecution because of that. Two, is they also want to expand that disqualification to the entire Utah County Attorney's Office. That seems.
Is that because it was a group chat?
No, it is not. It is because when the attorney received the text messages from his relative, within minutes after the shooting, and they give there is a a quoted text of the text messages that the attorney have in this. It's an interesting filing. Minute of the text that the attorney was getting. Now the attorney, the state's prosecution believes that they do not believe that they will be calling the relative who is at UVU as a witness. And defense, Tyler's counsel, I think, rightly points out that we really don't know. And as a matter of fact, what they said was, discovery is still in an early stage. So, which I think is a signal. This is, this case is going to go on for a while. So they're looking to disqualify both because, one, the attorney in the office shared all of this with his colleagues in the prosecutor's office, and they do give case law and precedent. We have not gotten a reply yet from, at least as of yesterday. I haven't looked today. I will check over this week, and I'm going to just try and go into the case about once a week and get on a regular cadence, because I don't think anything that happens is going to be terribly time sensitive, urgent. But as long as I'm on a regular cadence, and I can give you and everyone on the space kind of this type of update.
So, what happens with these motions? So, what happens if the prosecution is completely disqualified? What does that do?
Well, if it was in the case of just one attorney, that one attorney would not be, engaged in the, they'd have to work on something else. They wouldn't be involved in this case. I don't know what happens if an entire attorney's office is disqualified. It seems like very egregious to take it. That just seems like a big step to disqualify the entire office because one attorney.
I don't see it going through.
I could see the one attorney being disqualified, but here's what it does do. Okay, if Tyler should be convicted, now we have a point of law that would be the basis for an appeal. An appeal, there could be a number of rules for appeal. So this is kind of teed up. So
isn't there already a litany of those?
There is some. They do cite some case law. They're very fact specific. They discuss it in the motion. And I'm sure there will be other case law that points, that would support not disqualifying the attorney. Key to this were the facts of the case because Tyler was charged with aggravated murder. When the charge is aggravated, there needs to be an aggravating factor. And in this case, the aggravating factor was putting at risk the safety and the lives and safety of other people other than Charlie Kirk. And obviously there are many other people. And so not only was the relative a witness, he was one of the persons that, made this an aggravating factor case. And they needed to be an aggravating factor, for it to be a death penalty case, for a capital murder case. And once again, the defense pointed out, they jumped the gun. They did not have to seek the death penalty until 60 days after the preliminary hearing, which isn't even set until January 16th. So this is the second time, not diligent, where the prosecution just jumped the gun right off the bat, declared they shouldn't have done that. and that may be that opened up the door more for the disqualification of the attorney and potentially the entire attorney's office.
So Slick Dog, I stepped away from the phone for a bit. If I understand, they're trying to disqualify the attorney or attorneys based on the fact that one of the attorney's relatives was at the rally. Is that it?
Yes, and sent text messages within 1 to 2 minutes to one of the attorneys. So there is a good case, and they are. This is not throwing stone. Like, this is not trying to attack the credibility or the integrity of the attorney for doing anything wrong. And when you hear conflicts of interest, that's often the first thing. I mean, it's human. That's the first thing that you're going to think of. In this case, it's just a natural bias that you may not even be able to see that bias show itself during the prosecution of the case. And the defense explains that in the motion. I think they do a very good job of that, probably better than I am right now. And also the prosecution, they disclosed the conflict. So they were transparent with opposing counsel that there, may be potential or perceived conflict of interest. So they did the right thing under the Utah rules of professional conduct. Now they're going to differ on the legal position of whether, there's a conflict that merits disqualification of the attorney. Now, I mean, my experience in dealing with conflicts is when you have a conflict, you got to look at it. Okay, so it's been disclosed. Good. Now, is there a way that it can be mitigated? Can we build guardrails around it? So that the attorney with the potential conflict doesn't become an actual conflict. And the defense's position is that in this case, the answer is no. I expect when the state files its response to the motion, it will say, yes, this is, this attorney will not be involved in depositions for anyone who was there that day. So something, I'm kind of made that up, but they reply, they'll certainly defend. The other thing is that they are now trying to impute that disqualification to the entire attorney's office, which seems that's a stretch. That seems to me a stretch. But there is precedent under Utah law that some case law that they cited, and so.
And if the judge goes against precedent and doesn't do it, then that's grounds for appeal later on.
Not necessarily.
No, because there's also precedent to the opposite direction.
There's case law. What it is, what it boils down to is discretion. So a judge has discretion to make decisions based on the specific factors. And so when you file an appeal, there's different standards of review. So you need to say is it an abuse? Was it a legal error? Did the judge just make a mistake like he did with the timing of issuing his order on preservation of evidence, where he jumped the gun by 2 days? The state never actually, they had 2 more days to file their reply. He didn't even give them a chance to reply before issuing the order. That's a legal error. That is the basis for appeal. Another type of appeal is, abuse of discretion, making the wrong decision. And there's different, and it goes from there. And so that would be but it does give a point of appeal if they need it. Now, we don't know if they would even, at the end, at this point, from a trial perspective, things are going very fast. It seems to us they're going slow, but if Tyler were to be convicted, and they appealed, I think, this would be a good candidate for an issue to raise on appeal. But the judge, failed to exercise discretion or abused his discretion by not disqualifying the entire attorney's office. If he did, I don't know how that would work mechanically. I don't have any experience in anything like that, but to disqualify the entire office does seem pretty extreme.
Look, Doc, do we know what the content of the text message that the...
Yeah, we do. Thank you for asking, because we know a whole lot more than that. And this is where I think this is a really interesting motion. Okay, so it's actually a 48-page filing. The first 14 pages is the motion itself. The motion begins with a brief, about a one-page description of the facts of the shooting, of what happened on that day. And from the point of view of other witnesses who had filed affidavits. In the appendix are there's 5 affidavits from witnesses who were there that day. These are handwritten affidavits that were submitted to the investigations office. And so what we have in this filing is really the first glimpse at evidence of what they got in the case. It's pretty cool. So I think, like I said, these are handwritten affidavits from people who were there. There was one student from Weber State University, and they are redacted, so we don't know the names of the people who wrote the affidavits. I would imagine that the affidavits, that there's probably many more, but these affidavits probably supported were good exemplars of the facts. They're nothing is overly redacted. It's really just the names. So for people like Sam or Blake that likes to have spent a lot of time looking at the blow by blow details, I would think that of more interest than just the attorney disqualification part, that they might want to take a look at what were actual witnesses saying.
Okay, so
The witnesses that I spoke to, and I spoke to 2, right, who were actually within, I would say, within like 10 yards, said that they heard the shot coming up from like forward into Charlie's right a little bit, which is kind of the opposite direction. I mean, it's not like the exact opposite, but in the field of things, if you have center left, and center right, the shooter, Tyler Robinson, the alleged shooter, was center left, right, which is the Losi building. And where the 2 witnesses that I spoke to, and one of these guys, I posted it on my timeline. If you guys go to my highlights, I actually interviewed him during a space, and I got it on my body cam when I was there at UVU. He said he heard the gunshot come from Charlie's right, which is a little adjacent, right? Like, and still feasible because it's not like a hard right, like a 45 degree or a 90 degree right. It's just a little bit to the right where he got hit in the neck would still be a visible shot from a shooter at that angle. So that's 2. And then another one who is the kid that got accosted by Cooper Brown, right, when he was giving the interview and describing where he heard the shot from, he also said that when he heard the shot, he looked to Charlie's right. Now, that's 3 individuals who said that they heard the gunshot come from a different direction as opposed to what's being described in the charging documents of the Utah prosecutors, which I think is did the individual that you're describing, and I may have missed it because I was going through reading something, did the individual you're talking about describe where you heard the shot come from, Slick Dog?
Well, one of them did. Remember, there's 4 different affidavits that are attached as exhibits here. So then Charlie, I'm going to read directly from one of them. And I don't like doing this on the fly, but this is interesting because this is new. This is new information. Just set aside the attorney disqualification. These exhibits are interesting. Then Charlie got out about 2 or 3 words when the shot went off. My eyes flicked back behind me and to the right slightly, so I was looking over my right shoulder. It sounded like it came back of that area we were in, and it sounded like it came from an elevated location.
Where was he sitting?
They were sitting, let me scroll up. our way down to the front row and the corner of the barricade. So we were right in the front row on the left if you're facing the booth. We arrived around 11:50.
Okay.
At that.
Okay, so he is directly 90 degrees to Charlie's right.
Yeah.
45 or 90 degrees. He's to Charlie's right, and he's facing Charlie.
Yeah, and so you should really take some time and just look at.
So I definitely will over Christmas, especially. I have so much to read up on. I have a fucking mountain. I've been downloading Epstein files. I have like thousands of Epstein files to go through. I have so much to catch up on Charlie Kirk. We have a mountain of fucking legal documents to go through. Like, I really do need a team. Like, I am like to the point where I need a dedicated team to help me go through it all, because it's too much for me to do on my own. There is I just wish I had the money to pay him. But if you're willing to volunteer, there's an opening for you. So if there is
I can commit.
I want to go by what you said. Hold on. I want to go by what you said. You said he is at the corner of the barricade to the left of Charlie. If you're facing Charlie, which would have been Charlie's right, he heard the shot, and then he looked back over his shoulder. That kind of aligns with. Well, I mean, it depends on how far back you looked over. Over his shoulder, that implies a sharp turn, because you're looking almost backwards then, right? So that actually aligns back to that same corner as it sounds like, I could be wrong, sounds like the same account that I've heard from those other witnesses.
Yes, it does. No, I'm here. Can you hear me?
Yeah, yep.
Yeah, it does sound it, but you're really going to need, they're literally handwritten. Some go on for like 4 pages. I mean, they talk about like, when they were walking up, when they ran away.
Can you send me that specific document, a screenshot or a link for that?
You already have done a screenshot because it's 4 pages. You already have it. It's in the Dropbox in the file called Attorney Disqualification.
Okay, but my DMs get buried, so can you resend whatever chat it is? Can you just send like anything and it'll bring it back to the top of my DMs, because my DMs are crazy. All
right, let me do that right now.
Yeah, I don't know what X did, but when I'm on my iPhone and I look at DMs, it merged all of the filtered, like half of the filtered, and then half of them are not filtered. My DMs are a fucking mess. They're a mess.
All right, so
that's good. Thank you so much, Slick Dog. I appreciate it. I will go over it tonight.
So I just sent it to you. I just sent you a note, and you can pull it up, and then I'll drop into the subscriber chat too.
Thank you. Do you guys?
Before we move on, so Slick Dog, you never.
Well, hold on. My listeners and my speakers, especially. Do you guys want me to do a New Year's Eve space on Epstein and Charlie Kirk? Give me a thumbs up or a 100 down there in the listener section if you want me to do a space tomorrow, or what? Because I will do one. I'm not going to do one Christmas Day because I'm going to spend time with my daughter. But if you want me to do one tomorrow evening or tomorrow, I will. Give me a thumbs up or a 100. You got to show up, though. If you're giving me a 100 or a thumbs up, you have to show up. It looks like yes. All right, we'll do one. All right, cool. All right, awesome. Go. What was that, AB? Go ahead.
Yeah, no, just really quick. Slick Dog, you said that the motion did say what the contents of the text message was, but you never told us what it said, more or less. You can paraphrase slightly.
Okay. Actually, let me just read from the motion. You're talking about the text from the relative.
Yeah, the text from the relatives.
Okay, it's pretty short, so I can do that. Amy, I can send you a link to the filing as well if you want.
That'd be great. Thank you. between the
Make
relative
sure
and
you
one.
wear protection, Slick Dog. That's all I'm gonna say.
Okay, Mr. Blank, meaning the attorney, has described the text message exchange as follows. So this is in the words of the attorney. This is not the text. So I will point out when it's from the text. So the attorney said the following: Charlie Kirk was shot at 12:23 p.m. and at 12:25 p.m. I believe it's he. It's redacted. It's either he or she. I think it's a he. Texted my family text group saying, quote, someone got shot, in all caps. And almost immediately afterward, he or she texted the same group, quote, I'm okay. Everyone is going inside. At 12:26 p.m., he or she texted the same group, all caps, Charlie got shot. At 12:30 p.m., he or she texted the same group, people say he was shot in the neck and his head tilted or something. At 12:33 p.m., I texted my blank, niece, nephew, cousin, whoever he was. At 12:33 p.m., I texted my blank, quote, did you hear a gunshot or what sounded like a gunshot? Unquote. She responded to me at 12:38 p.m. Quote, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck. Not sure. Unquote.
Okay, so that's the exchange between one of the lawyers in the prosecutor's office and a relative of the lawyers.
And a relative of the lawyers, yeah.
And that's not verbatim, but that's from the prosecutor's account of the exchange.
Yes.
Okay.
Reconstructed text message.
That is what they disclosed to opposing counsel. So, again, I mean, it's not the.
Did we ever figure out what the hearing was about back in October? That was all redacted and secret.
No, but there. One thing I didn't mention when I gave my update is there are a whole other entries of activity dealing with motions in regards to seal and unsealed transcripts and audio of hearings that I just haven't had. I mean, as of Monday, there were 247 case events. So that's 247 filings. Now, a lot of those are just certificates of service, receipts of receiving the certificate of service. Probably, half of them are that, but that's still there's a ton. So I'm just trying to gather, the most material filings.
Okay. Thank you, Slick Dog. I will look through the Dropbox over the next couple of days. Christmas Eve, or Christmas night. Christmas, whatever. Okay. The evening of Christmas, I will look through it, and then. Right.
And then I'll put it in the subscriber chat, and if anyone else wants to geek out, and
if you're worried about like proliferating it too much, or if it links back to you at all, if you're worried about anything,
I'm not.
Okay.
I'm not. I mean, I'm happy to share. If someone really just wants to, pour through, legal documents. I
think the more eyes that we have going through it, the better, right?
I just find it. I also get excited I just find it intellectually interesting, kind of the different legal issues. So things that I get excited about may not be the same things that people in the space get excited about. But I do think the affidavits are worthwhile to get more eyes on. So.
Well, I think there's no detail that's too frivolous when it comes to something of this magnitude. This case has massive implications for our country. So, thank you, Slick Dog. We appreciate everything that you do. Make sure you guys are all following him. Carol, welcome. We haven't had you up here in a while. Are you going to be our last speaker?
Yes. Okay. Hi, everyone. It's great to be back. I'm usually here listening, but I haven't spoken for a while. I should have saved my comment, perhaps, until the subscriber space, so as to not, dox myself. I'm here under my real name. I heard you say that you're looking for volunteers. Well, I'm ready to sign up. I don't know if you guys.
We got a diligent citizen army on the
I'm one of the
march.
oldest people here, probably. Probably.
I was at a Memorial for Charlie Kirk in Northwest Florida. Babylon B was there. The at least one of the